call case number 112131, Vivian Mundy v. State of Kansas.
Your Honor, I would request 3 minutes for rebuttal.
3 minutes is granted.
May it please the court again, Kristen Patty, court of appointed counsel for Vivian Mundy, the appellant. I know you want a short summary of the facts, and this case in some ways couldn't get more simpler. This case is about 1 minute. In late March 2013, this court denied Vivian Mundy's petition for review from her direct appeal. 3.5 weeks later, she was released from probation. In between, she filed a pro se 1507 motion. 1 minute later, the district court appointed counsel to represent her. One of the issues that I briefed was the job that the court-appointed counsel did in representing her. I thought he failed her completely. But this is, again, where that 1 minute comes in. The Court of Appeals said, 1 minute, we're just going to pretend like that didn't happen. It's obvious that the district court in 1 minute couldn't have conducted the review of Ms. Mundy's petition to determine whether she had at least potentially substantial and compelling arguments to appoint counsel for her. So we're going to ignore that. The Court of Appeals looked at her motion and determined, well, she didn't deserve counsel anyway, and they affirmed the district court. And that's why we filed the petition for review that was granted last February. So again, this case comes down to how you view that 1 minute and whether you think that that 1 minute is important. I think that this court doesn't want to give the impression to anyone who may receive an appointment order that they're free to ignore it and not do anything and hope that the Court of Appeals or this court says that that's okay on appeal. I think that this case is a perfect opportunity for this court to define what it means, what it meant in Brown by the phrase most minimal of standards. That is, when counsel is appointed for a movement in a 1507 motion, or really in some ways a motion to withdraw a plea, a motion to correct a legal sentence, any sort of post-conviction motion where counsel can be appointed under 224506, what is required of them? And potentially that means that maybe even that this court does have the power to amend Rule 183 if that is further appropriate. In the brief, and I included it also in the petition for review because I wanted to make sure that the argument regarding court-appointed counsel was preserved for review. I used 4 cases from different jurisdictions where admittedly sometimes it is required under those jurisdictions statutes or rules, but those courts found counsel in post-conviction cases to be ineffective because they didn't do enough in the court's view to help their clients.
Are we in a fundamentally different place because of the difference in the rules? For example, the New Jersey rule requires counsel to certify that I have looked at the pro se pleadings and have made a conscious decision for strategic or other reasons not to amend the pleading. Here we don't have that kind of a record before us, and so under our Robertson decision, we are left with the possibility that it could be effective assistance of counsel to be silent if that attorney had an ethical duty to do it in that way or had made a strategic decision that it was better to allow the court to apply the liberality that would be given to a pro se pleading?
I guess my best way to answer that is by analogy. I represent, I'm court appointed to represent appellants all the time, and I struggle sometimes to balance my ethical duties and balance my effective representation of my client. And Justice Byers' words in Robertson, "So be it," ring in my head constantly. I've got a case in front of the Court of Appeals now where I did the statement of facts for a brief, and I got to the argument, and it's one of those times where I got nothing. But I can't not file a brief. I have to file something. And so I filed a motion for summary disposition, which is still pending, to at least let the court know that what I've reviewed and what the procedural history is. And I think that's part of the problem here is we don't have any indication that Ms. Mundy's counsel provided her with any sort of representation.
But you have apparently elected not to take a course of asking us to remand for a Van Cleve hearing. That would allow the possibility of a record of all of those kinds of things to be developed.
Right.
So we are at a situation, aren't we, that we are left just looking at the record? And how, based on that record, do we make the determination that you're suggesting?
I think that the state's response to Ms. Mundy's motion and the fact that Mr. Meyer didn't at least try to advocate for Ms. Mundy, that there was never sort of a preliminary hearing set where he could do, as is suggested in Robertson, stand on the client's written arguments. I think it does leave us wondering, but I think because of that, because of the gap in the record, because it doesn't appear from the record that he did anything, I don't know that a Van Cleve remand is appropriate here. If there had even...
Excuse me, counsel, isn't that exactly what we do with Van Cleve? We flesh out an incomplete record so that we can dispose of claims about ineffective assistance of counsel in a way that conserves judicial resources?
Yes, and I guess part of it is, to be honest, at the time I was getting ready to file this brief, I had only requested one Van Cleve remand, and it had not been granted. So I was looking at the guidance that I could find as far as what I needed to do to request a Van Cleve remand, and was not optimistic that one would be granted. And I couldn't say, other cases where I have been successful in since then getting Van Cleve remands. The client has received representation from the counsel at issue, but there's something lacking in that representation that I can point to. And in one case in particular, frankly, it made filing a brief in front of, for the client, because it had to do with the search warrant, it made really doing the brief irrelevant. And like I said, I wasn't optimistic at the time that I could get a Van Cleve remand in this case. The fact that he did nothing other than file a petition for review, a notice of appeal, that, as the Court of Appeals even pointed out, he failed to identify his own ineffectiveness, makes me think that it is appropriate for this court to rule on his representation with the record that has been established. And like I said, I think this does give the court an opportunity to define what do you mean by most minimal standards in Brown.
Just let me clarify then, as I understand your answer to Justice Byer's question, essentially you would be saying that if we feel we can't rule on the record before us, that we are done. We don't have the ability to go any further in looking at the ineffective assistance of counsel claims against the 1507 attorney?
No, I think, I mean, I'd like you to. I think that the record is sufficient.
I understand that.
Yeah.
If we disagree.
Yeah, I would, I would probably, I guess then she gets an ineffective assistance claim against me for not having requested the Van Cleve remand. I don't know whether there are any further questions about the
Let's-
council issue.
Let's take the next step.
Okay.
If we do agree with you that counsel, Mr. Meyer, I believe, did not meet Brown's minimal standards, so what? We have a finding that from the Court of Appeals, or a holding that the records and based on other opinions in the case record here, that it conclusively showed he was not entitled to relief anyway. And so there would be no prejudice from that, and you would lose anyway, right? Unless you can overcome that holding.
Right. I guess this is a argument I keep raising. In my mind, this court's opinion in Lujan gives district courts three options. If a judge certainly looks at a pro se petition and, we see for example, trial errors that can't be raised, or, certainly the second and successive ones, and knows that it can't be, that he or she can just dismiss it without getting input from either side, then that's fine. But then beyond that, if the district court requests input from the state, then the district court also needs to request input from counsel for the movant. And certainly then that's when the second and the third options come into play, the preliminary hearing and the evidentiary hearing. And the district court here kind of used something that isn't sanctioned by Lujan. It took what the state said and it used that as part of the basis for its decision. It also really reviewed and dismissed Ms. Mundy's 1507 motion almost as if she had that evidentiary hearing. Well, she didn't establish prejudice. She didn't establish deficient performance. And that's why we have the evidentiary hearing to begin with. So,
Counsel, is there a reason Lujan shouldn't have a fourth option added to it? I mean, is it possible that this scenario just was unanticipated and that this should also be available to district courts when evaluating 1507s? Is there anything in the law that you can cite us to that should prevent that kind of a ruling from this court?
I guess part of that is, the best answer is Lujan parrots the statute, and the statute doesn't give that option. So that's why I don't know that there is a fourth option.
Is it possible that fourth option is just implicit? That a judge always has a right to change his or her view of a case before a final judgment is entered, and that the judge may make a decision but then change his or her mind and decide, no, really upon further examination, the files, records, and motion don't reveal any triable issues of fact or serious questions of law.
Well, and that may be possible in some other cases. And you know, one of the things that I said in the conclusion of my petition for review is, you know, I understand that with the requirements for a 1507 motion and Swenson, for example, you don't want to have different standards depending on whether it's a first or a second or a 22nd 1507 movement. And yet, this is the way that we do provide for redress of constitutional claims. And Justice Johnson, I keep using, I think it's a concurrence from when you were in the Court of Appeals, because that's the only place that I've ever found, I haven't looked lately, but where we tie the 1507 procedure to providing due process. And frankly, I think the 1507 procedure, we expect maybe too much of pro se litigants on that first 1507 motion. And they may have some very valid constitutional claims, but if they can't afford counsel to review their record and file their motion for them, they're never, ever going to get those claims addressed. And after all, one of Ms. Mundy's claims has to do with witnesses and whether her trial counsel interviewed the witnesses that she thought was important to her case.
Do we have any further questions?
Yeah, when I can't cite you to the case, but I'm recalling that recently we had a circumstance where the trial judge had set a hearing. And before that hearing had changed his or her mind, I can't even remember where it was out of, and said, I'm going to summarily deny it after looking at it. And the argument was that that was a violation of Mouvan's due process, whatever. And we said no. No, it was an authorized, summary denial is an authorized under the statute, and it doesn't have to precede anything else, doesn't have to precede the appointment of counsel. So I think we decided that was appropriate. How does that play into your...
Well, I guess then the question back would be whether the district court judge got input from both sides, or whether he just did it of his own. I got an appointment order on Monday, and I was in a 1507, and I was looking at the case, and in that, the district court records, and the judge had appointed counsel who'd filed a pretrial questionnaire, and then it was decided that they wouldn't go ahead and actually have an evidentiary hearing on the record, but that's in the journal entry, which, at least I can tell from, I can't make this argument in that case, I don't think, because it does appear that my client had the benefit of counsel from that. So Justice Johnson, I don't know if that answers your question. If there are no other questions, I'll come back and rebuttal.
Thank you, counsel.
May it please the court. No, I'm not Alma Heckler. My name is John Simpson, Assistant Solicitor General for the state, and I just recently entered my appearance and received this case. And before I present any argument to the court, I believe that it's appropriate and helpful to review for the court the analytical process that I think the court should take in deciding the issues in this case. I think first the court needs to review whether the actions and rulings of the district court were appropriate. And then second, the court should turn to the claim that 1507 counsel was ineffective. And in reviewing that claim, the court first has to analyze whether review is appropriate. First, because whether this court has jurisdiction over the claim. And then second, because well, the court has to determine whether the record is adequate for the court to rule on the issue at all. And then if it makes a finding that there's jurisdiction and it can rule, then we can turn to the merits. And in this case, looking at the district court's actions, I don't think that there's anything that this court can read into Lujan that says, or that relieves a movement of their obligations to plead a plausible claim for relief in order to receive any kind of hearing. Excuse me. The only mandatory directive that Lujan issues is that if substantial issues exist from the pleading, and those substantial issues involve facts relating to events that the movement participated in, then the court has to have a hearing and the movement must be allowed to participate. Apart from that, I think that the avenues or, quote, approaches Lujan identifies are entirely discretionary, and they leave the court discretion to determine if a hearing is at all necessary or whether summary denial is appropriate. Regarding the court's ruling in this case, I think that it was entirely appropriate that Ms. Mundy pled no plausible claims of ineffective assistance. Specifically on appeal, only 2 of those 8 claims in the motion have been referred to or argued upon, and that's claim that trial counsel failed to failed to subpoena all the witnesses, and then failed to interview or subpoena witnesses that Ms. Mundy had requested that he subpoena or interview because, quote, he did not feel that head trauma cases would make good witnesses. And I think that those claims in particular are determinable without any kind of hearing from the record in the files. Regarding prejudice, this court has, this and Kansas, the Court of Appeals has held that a movement must plead some sort of evidence or proffer of what witnesses would testify to in order for the court to make any kind of determination that the evidence of those witnesses would have been admissible and would have been potentially outcome altering in the trial. And we have no sort of proffer from the face of Ms. Mundy's petition that would allow the court to make that kind of determination. In addition, what we know from the face of the petition is that 2 of the witnesses she claims were not subpoenaed or interviewed. Of those, one of those witnesses actually testified at trial. One of those and that's Kim Flading. One of those witnesses was subpoenaed by trial counsel, although it appears she did not testify at trial. And so add to that the failure to proffer any kind of potential testimony, and it's clear that the court was given no basis to determine that there was prejudice. Deficiency-wise, as a matter of law, Ms. Mundy's petition gave the court no basis to conclude that counsel's performance was deficient in deciding not to interview or subpoena witnesses who were head trauma or suffered from head trauma symptoms because he believed that they would be poor witnesses. The law makes clear that in the decisions about investigation or decisions about what witnesses to call are left to counsel, counsel has to exercise those choices reasonably. But in this case, I think that we look to the record and we see that there's support for the idea that that these head trauma victims had memory problems, and that the, quote, one day they would be your best friend and the next day they would hate your guts. And we see also that trial counsel called 8 witnesses on behalf of Ms. Mundy, and he also earned her acquittal on one of the counts. And reviewing all that against the sparse pleadings, I think we can see that the court was right to say there's no basis to conclude that no reasonable counsel would have acted as trial counsel. I know that's a bit poorly worded, but that specifically relating to that allegation, the court was also to determine there was no deficiency as a matter of law.
You've just made a very compelling argument that Mr. Myers was probably ineffective for not taking steps to amend his client's pleading and to add all of those details those proffers, any affidavits, anything like that. And that, because as you make it sound, it was pretty obvious from the face of the motion that it was insufficient.
I think all we can say is it's obvious the motion is deficient. We can't say that, especially because there's been no proffer about what counsel could have done to amend the petition. We can't say that he could have taken reasonable actions to save the petition. And I think that even reaching the issue of his deficiency is inappropriate. One, because there's a jurisdictional question at issue, although I don't think that's the hurdle here. And then second, I think that there's a question about whether the record is sufficient to review and determine the claim.
Explain what you just said about jurisdiction, that you don't think that's the hurdle.
Right, I believe the Court of Appeals determined it did not have jurisdiction to review this claim because it construed the notice of appeal narrowly and decided that it was not properly noticed and therefore the court had no jurisdiction.
And Ms.
We've
Funday
already,
has,
excuse me,
Sorry?
we've already said that that's not correct as a matter of law,
Okay.
haven't we?
Well, that's where I would have directed this court, but it beat me there, and I just now entering the case didn't realize that. But regarding whether the record is sufficient for this court to review the claim, I think that the record is sufficient under Robinson to make the determination that the motions, files, and records show that no substantial issues existed when Mr. Meyer was appointed, and that's the standard this court applied in Robinson. But anything beyond making that determination, I think, would require factual findings that this court does not have and has not been asked to make. And it shouldn't exercise its discretion to allow those findings in this case, in large part because, again, the solemn caveat that Van Cleave speaks about has not been fulfilled. There's been no assurance that a beyond-the-record investigation into Mr. Meyer's performance has been conducted, and there's been no proffer about, again, what actions he could have taken or what his inactions actually denied Ms. Bundy. In looking to Brown and Robinson, I think that the only circumstances under which this court can find deficiency on a sparse record are if counsel abdicated his role as the movement's advocate in favor of an adversarial role, or if counsel's actions denied the movement the opportunity to exercise a right that the movement had, which in Brown's case was the right to appeal. And there's no evidence of those circumstances in this case. So, particularly regarding counsel's invitation to this court to define the most minimal standards that 1507 counsel should follow or adhere to, I think that Brown set those standards, Robertson set those standards, as I just discussed, and that anything beyond that, any invitation to oppose affirmative obligations on counsel as though those obligations were required in every case, regardless of that case's circumstances, would be difficult to make such a sweeping rule, given that Strickland's standard is designed to be flexible, and it asks not what a prudent attorney would have done, not what was appropriate, but whether no reasonable attorney would have acted the same way under the identical circumstances. It also contravenes or would create some tension, I think, with our case law that says that that where courts have refused to find counsel ineffective for abandoning or not pursuing meritless issues. And then also there's the fact that the legislative intent at issue here regarding appointment of counsel and the attendant right to effective counsel is conditioned on the movement but making a sufficient showing in their pleadings that substantial issues exist. And then finally, I think, and this is what this case illustrates, is that it just ignores the reality that district courts appoint counsel as a perfunctory matter. And that's not something that was directly addressed in Lujan. And I think that
Say that again. What's your point here? That
the point
district courts appoint counsel in just a perfunctory kind of way and expect them to do nothing?
No, what I'm saying
what's
is.
your point?
Sorry, what?
I don't understand.
What I'm suggesting is the court shouldn't create some sweeping rule about, in every circumstance, an appointed counsel. Well, I guess the point I'm trying to make is that the courts have discretion to appoint counsel, and that Lujan does not. Well, I think that point is not relevant. I guess.
Well, no. Well, typically, when a counsel is appointed, it's with an expectation there's some form of representation, and if it doesn't warrant representation, shouldn't that at least be articulated somewhere by counsel? Here, my problem here is we don't know what Meyer did or didn't do, or why he didn't do or do something.
Right, I would
And
agree.
we just don't know.
I mean, I think once again, the case is determinable, if at all, on the fact that there was no prejudice, because under Robertson, when Meyer was appointed, Ms. Mundy's pleadings failed to state a plausible claim. But if this court were to speculate, or not speculate, but to potentially find that there was some possible prejudice, that there's no record that would allow this court to make a determination regarding deficiency, and no such request for those findings has been made, and it would be inappropriate in this case, given that there's no assurance that there's some plausible basis for claiming that Meyer was ineffective.
What would be the harm of a Van Cleve kind of remedy to try to determine what did occur with Meyer's representation?
I think the harm, first of all, I mean, it obviously involves judicial resources, a fair amount of judicial resources, and when you're making the determination about whether those resources or expending those resources is justified, there's no basis to conclude that it is in this case.
So it's a judicial economy kind of concern?
I think that's the foremost concern. I think that the state, I mean, obviously, anytime a ruling that's favorable to a party is reexamined, it's prejudicial in a sense. So there's that prejudice. But obviously, if there's a justifiable basis for reexamining that ruling, then the prejudice of it is outweighed by the potential possibility that the individual had some sort of, or something went wrong.
Counsel, your opponent said that that Lujan, I guess is how we're pronouncing it today, tracked or parroted the statute. I assume that to be 1507 itself, and that's why there are only these three options, or should only be three options available to a district court faced with a 1507 motion. The first option, of course, being a summary proceeding where no counsel is appointed, no hearing is held. The motion, files, and records just determine the outcome against the petitioner or movement. And then the second, involving a hearing of some sort once counsel's been appointed, either a non-evidentiary or an evidentiary hearing. And she said the reason those three should be limited to those three can be found in the words of the statute. Do you have any counter argument to that argument?
I would just, nothing except that my reading of the statute is not, I don't think it's direct from the statute that those are the only options. I think the statute only directs that a movement has the obligation to plead substantial issues, and then every action, apart from that discussed in Lujan of having a hearing with the movement president if there are substantial issues in which the movement participated, apart from that option, everything is discretionary.
Or a gloss on the statutory language. A court gloss on the statutory language.
Right, and I think dicta to be true, because I don't think it was required in that case to outline every procedure that the court was available to the court to decide the case.
Okay, because the way the statute's drawn is that there's an entitlement to a hearing on a motion unless the the motion files and records show that none's needed. Basically, that's the wording of the
Correct.
statute. And everything after that came out of the case law, not the wording of the statute, right?
That's my understanding.
Which means that perhaps there also exists this weigh station that happened in this case, where counsel was appointed, court thought
Right.
better of it, didn't have a hearing.
Right, and I think if the court is looking at what the impact of the district court's actual actions are under Lujan or its options, that this court made a very persuasive argument in, I might mistake the pronunciation here, Kowalik. And in that case, the court examined the same sort of syllogism that's at play here, which suggests that if a court acts to appoint counsel, if a court acts to hold a hearing, that necessarily means substantial issues exist and movement was somehow entitled to something. And in that opinion, this court decided that sort of reasoning is flawed because there's no requirement that a court, I believe the language was that the court's actions are not forbidden where substantial issues are absent, suggesting that the court can take those discretionary actions. So I would just encourage the court perhaps to consider the Kowalik decision and in determining whether the procedures of Lujan are required or not. I see that my time has expired. May I have leave to briefly conclude?
I was going to ask you,
Can I ask?
sure.
I just want to be sure that I am understood correctly your exchange between Justice Beyer about the jurisdiction issue.
Okay.
And you were saying that you would agree that the Court of Appeals was wrong in that ruling because of our decision in Robertson. Is that correct?
Well, I don't know that Robertson squarely addresses the issue, and I'm not aware of what the notice of appeal in Robertson's case actually stated.
I think
But
in Robertson, we said it was raised for the first time on appeal.
Right.
Ineffectiveness of-
I guess in my limited experience, I don't know if that's conclusive proof that it wasn't contained in the notice of appeal or if it was. I just didn't directly assume that its facts were on point, but if they are, then I think that it does handle the jurisdictional issue. I think the only point I would have made to the court is that this court has essentially determined that defects in a notice of appeal are not a jurisdictional obstacle unless there's some sort of harm evident in the record that the other party suffered. And I don't think that analysis was undertaken at all by the Kansas Court of Appeals. And I would also suggest that Fuller v. State, which was a 1507 case, the court applied that rule in determining that the defects in the notice of appeal didn't bar the court from reviewing the claims in that case. Although, again, factually, that case isn't squarely on point because the issue to which the defects related was actually raised in the district court. If there are no further questions, I would just ask that the court affirm the district court's actions and rulings on our arguments and the state's briefs.
Any more questions? Thank you, counsel.
In thinking about it, I think Lujan might not flow from the statutory language of 60-1507, but might flow from one of the subparagraphs of 224506. And I don't have that statute in front of me at the moment. Ms. Mundy used the prescribed form. And, certainly we've all seen 1507 motions where pro se litigants attach a whole lot to them. But it would seem to some extent, too, that using the prescribed form is what this court has determined is minimally required. I think if the district court thought better of her motion and whether counsel should be appointed to represent her, then I would pose the opposite question. Why did it take it 10 months to decide that? If it had decided it in July rather than in February after she filed in April, it might be a little bit different. this, in some ways, seems to be the only type of proceeding where we almost require pro se litigants to meet the standard of proof in their motion. And that's not what's required. That's not why we permit counsel to be appointed for them. I know in one place in my brief, I point out that she still had 340 days in order to bring any claims under the statute of limitations of 1507F. And I certainly, I wanted to make sure that I highlighted the interviewing of the witnesses as part of one of the claims that could have been expanded upon by her court-appointed counsel. It's certainly difficult for me to look at one of her allegations. A friend of mine kept giving him legal counsel and seeing how her trial counsel was ineffective. But also, if the 1507 counsel had done an expanded type of pleading, perhaps it would have turned into something else. My time's about up. If there are no further questions, I would request that you reverse the Court of Appeals and the District Court.
I have no question, but I just want to clarify so you don't go looking for the case I mentioned.
Okay.
It involved a 223504 motion to correct an illegal sentence, so it's not applicable here. So I don't save you the time to go looking for a non-existent case.
Okay. And then since it isn't that, I won't, since I haven't read it, I won't expand on that then. Okay. Thank you very
Thank you.
much.
Any more questions of counsel before she sits down? Thank you. Appreciate the arguments from both of you this morning. The court will take this matter under advisement. Call the second case on this morning's docket, case number 115604, State of Kansas v. Butler.
Mr. Chief Justice, and may it please the court, my name is Kai Mann. I'm here from the Appellate Defender's Office on behalf of the appellant, Mr. Butler, and may I please reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. As far as a brief factual overview, Mr. Butler was convicted of 1 count each of first-degree murder, of felony first-degree murder, of conspiracy to commit aggravated robbery and an attempted aggravated robbery, all stemming from events that allegedly occurred on January 9th, 2013. Mr. Butler had a co-defendant in this case, Mr. Jewell, who ended up pleading with the state in exchange for cooperation at trial, at which he implicated Mr. Butler in the events on January 9th, which the evidence at trial suggested was a robbery motivated by Mr. Butler being unhappy with some prior marijuana deals with a Mr. Llanos, who he met through his co-workers, Mr. Cole and Mr. Barger. And on January 9th, 2013, Mr. Butler and Mr. Jewell went to Mr. Llanos' apartment after being apprised that he was there by Mr. Cole, at which point Mr. Butler went up to the room where other people were, shots occurred, and a Mr. Gibson was killed in the altercation. At trial, Mr. Butler was convicted, and we have raised 7 issues on appeal. The 7th issue is a sentencing issue. Just going to submit that on the briefs. Post-release v. parole, I believe the state conceded that resentencing needs to occur to do that. But as far as issue 1, related to the insufficiency of the evidence supporting the alternative overt acts of conspiracy, when Mr. Butler was charged with his conspiracy to commit aggravated robbery, the complaint alleged 3 overt acts. 1, discussing and planning the robbery. 2, arriving at the location of the robbery. And 3, actually carrying out the plan.
Were they joined by the conjunction "and" in the charge, like they were in the instruction?
You know, I can't recall off the top of my head, but I do have a copy of the charge. It says, and in furtherance of such agreement, committed the following overt act, to wit, discussed and planned robbing Nick Llanos and the roles of each person, then arrived at the location discussed and carried out the plan in violation of KSA.
So
202.
listed as a series of behaviors, not really as alternatives to one another. Same in the instruction. I think that's what you just read to me. That's what the instruction reads.
I read the complaint, and I have the instruction.
Take my word for it.
Yeah.
Okay, assuming for purposes of argument, the
That's what it says.
"and" appears in both places. How does that affect your argument? I mean, the jury wasn't really told you can view these as alternatives at all. The jury was told this is a series of behaviors that together make up the overt act.
And I understand, and I think that, perhaps, by the fact that I was confused by that for a minute here might lead to the fact that I'm not sure if a reasonable juror would view those series of events as one event, because, the planning and preparation, arriving at the location, and carrying out the plan all occur, unless this is just one big go meet up, let's do this, they all occur at different discrete times. Mr. Butler, the evidence showed, had been discussing robbing Mr. Llanos for at least a month prior to this, and attempting to enlist the help of his coworkers. And so I don't think that even if it was specifically and discreetly charged that way, I don't think that a jury would view those 3 elements of an alleged overt act as one overt act, as opposed to 3 overt acts. And I still think we end up in the same position of being completely unsure as to whether or not Mr. Butler was convicted on conspiracy for merely discussing and planning, or if the jury took it all together.
Before we even get to
Yes.
that question, don't we have to know one way or the other whether or not conspiracy is, whether or not we even have an alternative means situation?
Yes, that would be true.
So explain to me how the statute creates alternative means for committing conspiracy.
Well, the statute doesn't commit alternative means for committing.
And isn't that what we've said, that's where our analysis starts?
Yes.
Starts with the language of the statute.
It starts with the language of the statute, but I think that since an overt act can necessarily be anything that is close to showing consummation of the crime.
Different
Yeah.
factual scenarios can prove
Yes.
an overt act.
Right.
But our recent case law has tended at least to describe those as options within the means, has it not?
It has. I know that we cited to Enriquez at the Court of Appeals, and I also know, but I think that is one way to look at it. However, I think since we're dealing with a single element that's difficult to define and does have a factual component, I do think once you get to the point to where you're alleging multiple different things that could fit within an overt act, then even if the statute doesn't create it by its plain language, by the way it's presented to a jury, an alternative means problem can arise, requiring unanimity to make sure that the exact overt act was agreed on by all 12 jurors. So while not specifically created by the statute, I believe that the way these cases can be presented to a jury inherently create alternative means issues, as long as the state does not elect on a particular mean with which to instruct the jury on and
If
proceed
we
on.
accept that, and I think there's some skepticism, but if we accept that this somehow created an alternative means situation, then it isn't a matter of the jury having to be unanimous on the means. In fact, we said the opposite, haven't we? We've said the jury doesn't have to be unanimous on the means. They just need to have adequate proof of each of the means, right?
And that is true. However, if mere discussing and planning is one of the means, and that does not rise as a matter of
As a
law,
matter of law to an overt
to an
act.
overt act, then there can never be sufficient evidence on all three means at that point. So that is the distinction at this case, is that one of the means that we are alleging was mere preparation, which cannot complete a full conspiracy.
So it sounds to me like your argument is less of an alternative means sufficiency argument and more of a jury instruction argument, that the instruction misstated the law or was legally erroneous.
I think that could be an alternative way to raise the issue.
Well, and it might make a difference for our standard of review.
Yeah, I understand. And I think that given the state laid out within its complaint these three acts making either one discrete overt act or three different overt acts that the jury could then pick from, I think that brings it into a sufficiency as opposed to a jury instruction issue, although it certainly could be raised as a jury instruction issue. I think that's one of those things that you could raise twice depending on exactly how you want to attack it, or at least I would try at some point.
But if it had been in the complaint, but planning and discussing was not included in the jury instruction, I mean, that happens all the time with the evidence, where the jury instruction comports with the law, but the complaint doesn't.
Right.
Then you wouldn't have that argument.
No, would because at that point the state would have elected.
And so that tells me that the culprit here is the jury instruction.
Okay.
You understand what I'm
No,
saying?
yes, I understand what you're saying, and I think, that ultimately it's an error at some point, but whether or not it's classically a sufficiency error or more classically within a jury instruction error, I think that at the end of the day the jury was given multiple options as far as an overt act, but no attempt and consideration was given to make sure that the same act was on. However, since we are discussing jury instructions, I would like to move on to issue 2, and if that is okay.
I'd
What would
love
our-
for you to move on to issue 2. Go ahead. Do you have
If it
something
is
else?
if it is a jury instruction on this first issue, what would our standard of review be?
Your standard of review, I would believe, and I will double check the record, I do not believe that is requested a different instruction. So if it was not requested, it would be clearly erroneous. But I will double check that just to make sure, because I had not anticipated discussing that as a jury question issue. But as far as jury instruction issue, also on the conspiracy to commit aggravated robbery, the jury was only instructed that the crime, or that the defendant must commit the crime of conspiracy to aggravated robbery as knowingly. It is our position that this is a specific intent crime, as laid out by the elements within the jury instructions.
It actually kind of got mixed messages, didn't it? That's why I'm eager to move on to
Yes.
this issue. Because instruction number 19 said that it also dealt with conspiracy,
It did.
and its subparagraph 2 said the defendant did agree with his co-conspirator with the intent that the aggravated robbery be committed. So the jury was informed that there had to be an intention to commit the aggravated robbery. You're just saying that the second intention of conspiracy knowingly is insufficient.
Yes,
right?
and they were also never instructed on the definition of intentional and intent, which is above knowingly, and given that the element instruction of conspiracy involves an intent an intent to commit the underlying crime, I don't know if anybody could knowingly agree to something to do intentionally. I think at that point, I don't know how. I don't know how you could knowingly agree to do something intentionally without intentionally agreeing to do it.
Well, if that's true, then what's wrong with the instructions?
Is that knowingly represents a lower mens rea,
Right.
and therefore it doesn't impart the full culpability, the full mens rea to the jury that they must decide which is an element of the crime.
Does the conspiracy statute list a mental state?
It does not. I believe the conspiracy statute lists that the agreement must be done with the intent, or the agreement must be formed with the intent to commit the underlying crime, or whatever the conspiratorial crime is. But it does not say, intentionally enter into an agreement to commit. But I think that, again, if you are entering into an agreement to intend to commit a crime, that is the same thing as...
What do we do with our statute that says, effectively says, where a criminal statute does not list a specific mental state, knowingly is sufficient?
But I'm not exactly sure if that's true, because there is intent to the element of wanting to commit the underlying crime. So I'm not exactly sure that there's no mental state. There is a mental state leading to that specific element. And also, the proof of a higher mental state proves all the lower mental states. So to lessen confusion, and intentional instruction would have been far more appropriate here than the knowingly instruction to the jury and prevented confusion in the first place. And so therefore, the intent is used within the crime. The intent must be to commit the underlying crime that is agreed upon, but without the jury was never disclosed to that. And I see that I'm out of time.
But why, given the aggravated robbery intent, is this not harmless error? If the jury had to conclude
Right.
it was intentionally...
Because they were never given a definition of intentionally, so I don't know if the jury could ever fully appreciate whether or not an agreement was fully ever entered into with the requisite mental state required to sustain a conviction. And so I think that it'd be between that and the insufficient evidence as to the overt acts, along with the other errors. I think, even if standing alone isn't clear error, once the other errors are considered together, I think under cumulative error analysis that these together would produce prejudice.
But our harmless standard is clearly erroneous.
Yes.
So why should we be firmly convinced that the jury would have acquitted if this instruction had said intentionally instead of knowingly? What is there that would firmly convince me that changing that word would have resulted in an acquittal here?
Well, I think, there was the evidence of Mr. Cole that he did not want to participate in this conspiracy because he was friends with Mr. Llanos, but then he ended up texting him. I think that the way this conspiracy came together, I don't think it was ever clear outside of maybe Mr. Jewell, if a fully formed conspiracy was ever launched, or if this was more of an ad hoc robbery gone wrong and admitted to the day, or yet agreed to relatively soon before the robbery happened, when Mr. Jewell agreed to do this robbery on January 9th. But again, even if not standing alone, I still do think that especially when considered with the error in issue 1, and lack of limiting instruction, I think that there's, if not clear error, there is reversible error cumulatively. Excuse me.
Any more questions?
If I may, I have
Yes.
a couple follow-ups probably. Your argument is that the instruction on knowingly was a misstatement of the law.
Yes.
It's not legally appropriate, right?
Right.
And I'm trying to figure out what you would point this court to lead us to that conclusion. And I've heard you say that you point us to the statute on conspiracy, which you've said includes an element of intent, or includes the word intent. If that's not the case,
Yeah.
can you point us to anything else?
I will. Well, first I will check to make sure that is the case. I think the language of the instruction itself, the jury was instructed that the defendant did so agree with the intent that the aggravated robbery be committed. So I don't know. Again, I think that shows that there must be an intent here, because again, I
Well,
don't.
that instruction might be wrong,
Right.
but the instruction can't give content to the law.
No,
I mean, what is the mental state for conspiracy? That's the question.
I fully believe that it is, that it is a specific intent crime, that you enter into agreement with the intent.
Whether it's specific intent or not doesn't answer the question of what is the proper culpable mental state.
Well,
And so, what can you point us to that would indicate that knowingly is the wrong culpable mental state to assign to the crime of conspiracy in Kansas?
I mean, again, and unless I am mistaken, if there is an intent element associated, or if there is an intent associated with an element, then that intent has to be proven for that element. And furthermore, given that the only elements of conspiracy are agreement and overt act, if you intend to commit a crime during an agreement, I don't know how else a knowingly could get in there. I guess as far as logically in my own head, I don't see
how else that knowingly could get in there.
Yeah, because if I have to, in order to engage into a conspiracy, if I
can't-
have to agree,
Let me stop you
Yeah.
for just a second, if
Yeah.
you don't mind. I'm just trying to make sense of
Yeah.
what you just said. You can't agree without knowing you agree, can you?
That
I mean,
is-
that's just an impossibility.
that is true. But can I knowingly agree to something, to intend to do something without intending to enter that agreement? I guess what I'm saying is I don't know how I can knowingly agree to a conspiracy to intend to commit a crime without intending to. That's where I'm going, because the agreement itself.
And that alone, you think it's just a logical
I do.
fallacy?
I really do. I think it would be incredibly difficult, if not impossible, to agree to a conspiracy, but not intend to conspire to intend to commit the underlying crime.
Well, I don't think that's what happened here, though. They got instructed that that the agreement had to be knowing,
Right.
but there also had to be an intention to commit the underlying offense.
Yes, but again, I think that, and I'm doing a very poor job of explaining this, but if you have to agree to intend the underlying felony, and so you have to agree, or so you have to intend to commit that felony.
Mm-hmm.
I don't know if I can just knowingly
Agree? You think it has to
Agree.
be an intention to agree?
I think so, or
Other than
or
that,
else,
do you have anything else to give to my colleague who
no,
asked you
I do
for
not.
something supporting it?
unless I forgot the question.
That's fine, thank you.
Okay, thank you.
Any further questions? Thank you, Counsel.
Thank you.
May it please the court. Christopher Schneider, Assistant Wyandotte County District Attorney, on behalf of the appellee, the state of Kansas. And as a preliminary matter, I would agree that as far as issue number 7, the sentencing issue, the question of lifetime post-release versus lifetime parole, that the case needs to be remanded for resentencing to correct that issue. As for the conviction, it's the state's position that the district court should be affirmed, that the conviction should stand. As to the sufficiency of the evidence for the crime of a conspiracy to commit aggravated robbery, and again, the challenge is not to the other two counts, but as to the conspiracy to commit aggravated robbery, if you look at all the evidence in the light most favorable to the state, to determine if a rational fact finder could find the defendant guilty, I think the answer to that is yes, a rational fact finder could.
But if a rational jury could find that he planned and discussed, that legally that wouldn't be a overt act, would it?
If the planning and if all it is planning and discussion, then that's correct, and I noted that in the brief. If the only thing that was proven was planning and discussing, then no, you don't have the overt act. And it's clear you have to have that. You have to have the agreement, the planning and discussing the
The
agreement.
argument is, why is that part of the instruction with regard to overt act? Because, the act was going to the location and committing the crime.
Right.
Because that's what happened after the planning and discussion and.
But logically, to get to that point, it has to be, for a conspiracy, it has to be planned. It has to be an agreement to do that. So
That's the essence of
Element
the
number one.
crime, is
Right.
the agreement, but the agreement doesn't get you there. You have to then have something in furtherance of the agreement.
Right.
And when you say the act in furtherance of the agreement is the agreement, then that's confusing.
Well, no, because you're actually saying it's more than that, because you're saying that yes, it's the agreement, but you're also saying they went to the location and they attempted and they went to carry out an aggravated robbery, and they did that. They didn't succeed in the robbery. They ended up killing somebody in the process. But it's all of those things together. It's the whole conglomeration. And that's what. And
So
that's what
is it the state's position that the only thing that saves this instruction from being legally erroneous is the conjunction "and" between those three?
I'm not sure if that's
Acts.
the only thing, but I think it sure helps.
Well, let me rephrase the question. If the instruction, hypothetically, this isn't the instruction we have, but if the instruction had said planning and discussing, or driving to the location, or committing the robbery, would that be a correct statement of the law? Would that be legally appropriate?
One, it wouldn't be legally appropriate. Two, it wouldn't be a correct statement of the law.
Okay,
three,
and the reason is-
three, I think that might be reversible error.
Well, the reason is because, as Justice Johnson just pointed out, you don't have planning and discussing isn't sufficient by itself to be an overt act. So is that enough to save this instruction, I guess, the difference between and or does it create needless and unnecessary confusion in the minds of the jury?
I think it is sufficient. First of all, I think it is sufficient. Secondly, I don't think it creates mindless confusion, because you've already told them they have to find that agreement, the planning and discussing. You've already told them they have to find that. So it's basically redundant, if anything.
But that redundancy, again, if just the changing, and we've already established just the changing of and or could move this instruction into error territory.
Correct.
And so just make your best argument to me why that's not confusing. That unnecessary redundancy does seem to me to lead potentially to confusion in the minds of the jury.
I think you, and with all due respect, I think you may be faulting our jurors to some extent, because I think what we're telling them is you have to find all of these things, and all of them,
That's
and
not
they
what-
have to find all of those things for the conspiracy to be there, albeit the agreement is a separate line of that instruction, separate.
And then it repeats the agreement in the overt act
And we're
instruction.
saying again that there has to be this agreement, but we're not just saying there just has to be this agreement or something or something. There has to be this, there has to be the going to the location, and there has to be the effort to carry out.
You're just saying no reasonable juror would be confused into thinking that the agreement itself can be an overt act.
Correct. So even if the instruction is erroneous, the error is harmless, because it's certainly not clear error. It's certainly not when you look at the totality. Even if the wording is not what you as judges, we as lawyers think it should be, the end result's not going to be different. It's not the error is harmless. And I think it's important to keep in mind too that with the conspiracy, it's not a conspiracy is not an instantaneous or at least oftentimes it's not an instantaneous crime. It takes place over time, as it did in this case, with Mr. Butler being dissatisfied with his purchase of marijuana from Mr. Llanos and stewing about it and wanting to do something about it, discussing the matter and recruiting co-conspirators. And finally, he and Mr. Jewell agree this is what they're going to do, and they take the necessary steps to carry it out.
Excuse me, counsel, are you now explaining why this error is harmless, or what is your underlying point?
Well, I think the point is, counsel argued that some of the discussion started some time before, a matter of weeks before the actual events on January 9th, 2013. And what I'm saying is that's normal for a conspiracy. That this isn't an instantaneous. It's not something that necessarily has to happen instantaneously or bang 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 one right after the other. It can congeal over time, and that's what we have here. That's my point. Is that it sort of congeals over time. And then moving on, the district court did correctly instruct the jury on the crime of conspiracy to commit aggravated robbery. There was no objection to the instruction. The conspiracy statute itself, as was discussed, doesn't specify a required culpable mental state in general. It does say that there has to be intent to commit the underlying crime, which in this case was aggravated robbery. But it doesn't specify that the defendant has to knowingly or intentionally or recklessly. So the statute, the legislature has said where a statute doesn't specify which culpable mental state, any of the three will suffice. And the court chose to instruct the jury as with the mental state of knowingly. And it was a correct instruction. There was no objection to that. It's not clearly erroneous because there had to be a knowing agreement, which the evidence showed there was, but it also had to be the intent to commit that robbery, and that's what the defendant and his co-defendant intended to do. They went to the residence at 83rd and Monroe, and they went there to commit an aggravated robbery. Unfortunately, it went really bad. So the district court did correctly instruct the jury, and given that the district court's rulings were not erroneous, there cannot be cumulative error. So I would ask the court to affirm the decision of the district court on those matters.
I have a question about a different issue.
Yes, Your Honor.
On the way to forming this conspiracy, as you allege, there were other crimes elicited, sale of marijuana, threats towards Cole and Barger, threats and regarding the potential robbery of Llanos. Defendant alleges that those would require some limiting instructions. Why don't they require some limiting instructions? They're prior crimes or civil wrongs and talking about criminal activity. Why wasn't a limiting instruction appropriate on some of this conduct?
Well, because it's all part and parcel of the crime of conspiracy. The discussions as to the prior marijuana transactions between Llanos and Butler, that's what gave rise to the conspiracy. If it wasn't but for those, there wouldn't be there.
So if there's evidence deduced that it's part of the conspiracy, then there's kind of carte blanche allows for any kind of evidence requiring other criminal activity.
Well, no, it's not carte blanche. I think it has to relate to the conspiracy or to the underlying crimes, but I don't think it's carte blanche. It certainly has to be relevant and has to relate. And I think in this case, all of those things did.
Do you have any further presentation?
I have no further presentation. Unless there are further questions from the court, I would ask that the decision of the district court be affirmed.
Do you have-
I was just going to ask about the prosecutorial error issue, just so we can hear your side of it, particularly on harmlessness, if we were to
Well-
decide there was error.
First of all, it's not. First of all, it's not error, and secondly, if it is error, it's harmless. The counsel on rebuttal responded to defense counsel in his closing argument, alleged that the state's theory of the case was ridiculous, and the prosecutor on rebuttal attempted to rebut that and basically said, first of all, our case isn't ridiculous. The only use of the word ridiculous by the prosecutor was in response to the challenge to the state, the challenge by defense counsel that the state's case was ridiculous, that the state's theory was ridiculous. And that's what it's centered around, is refuting that there was nothing ridiculous about the state's theory of the case. The prosecutor did not impugn the defendant. He didn't impugn defense counsel or any witnesses or anyone else, or make light of defendant's argument. He just basically responded to the allegation that the state's arguments are ridiculous. And he said, no, they're not, and here's why they're not ridiculous. And he ended with a rhetorical question. So I would argue, first of all, that's not error. And if for some reason that it would be found to be error, if you look at the context, look at the whole context of it, it's harmless.
Was it fair comment by defense counsel to call the state's case or theory ridiculous?
Well, if defense counsel is going to be held to the same standard as we as prosecutors are, then no, it's not fair. But it happened.
Well, I know it happened. My question is, with putting aside the standards that we hold prosecutors to, is it fair comment by defense counsel?
No.
And your response is, because it was not fair comment, it's okay for the prosecutor to respond in kind to an unfair comment?
No, Your Honor, because the prosecutor didn't respond in kind. The prosecutor didn't turn around and say, hey, defendant, your argument's ridiculous. That's not what the prosecutor did at all. The prosecutor basically said, here's why my argument, here's why the state's argument is not ridiculous.
Well, why isn't it fair comment for the defense attorney to say that? I mean, these are jury trials. You're arguing to a jury. Well, maybe it's wrong,
Well,
but why isn't it fair comment?
Well, because I think for it to be fair, and the Chief Justice and I kind of had this discussion just a minute ago. If I, as a prosecutor, stand in front of a jury and say, defendant's argument is ridiculous, I'm probably going to get called on that.
Well, you just told us that wasn't error.
In this case, but the prosecutor didn't do that. The prosecutor didn't say the defendant's argument was ridiculous. The prosecutor said the prosecutor said my argument is not ridiculous, and here's why my argument is not ridiculous.
That's how it started. And then, as you said, there was a rhetorical question later about whether the defense argument, in fact, wasn't the ridiculous one.
I think
It's just kind of tit for tat. Once the defense lawyers said the state's theory was ridiculous, then the prosecutor did stand up and say, let me tell you the reasons why our theory isn't ridiculous. And by the way, their theory is X and ridiculous. You decide. I mean,
Right.
it was back and forth.
If I could refresh everybody's recollection, maybe that's what you're referring to.
Yeah, page.
Prosecutor says, where is this 7 to 10 person conspiracy to point out one man, a man that some don't know, a man the rest don't have a problem with? Ladies and gentlemen, ridiculous. Sounds like the prosecutor, he or she is referring to the defense argument.
See, I didn't take it that way. I took it as a rhetorical question when I read it. But
Any more questions? Any further presentation? All right, thank you, counsel.
thank you.
May I please court? Excuse me. Going back to issues to pick up from my first presentation, I did check there was no objection to the jury instructions as stated. And as far as the mental state for conspiracy, I will submit that subsection A, defining the conspiracy's agreement between another person, does not list a mental state, but subsection B does state that it is immaterial to the criminal liability of a person charged with conspiracy that any other person with whom the defendant conspired lacked the actual intent to commit the underlying crime, provided that the defendant believed that the other person did have the actual intent to commit the underlying crime. So therefore, there has to be an actual intent underlying the crime, and therefore, and I think subsection C, when it discusses with withdrawing from a conspiracy, also, again, does not state, but implies and can be read to infer a larger degree of culpability if you have to voluntarily withdraw.
What do we do with our older case law, like Campbell, et cetera, that describes the intent required for a conspiracy to be willful and or knowing?
I think that that case law should be overruled in favor of intent, given the statute clearly states that that there must be an actual intent somewhere in the conspiracy to commit the underlying crime. And so therefore, a knowingly, just instructing the jury on knowingly doesn't give them the full picture of the intent for a crime that does involve intent to commit the underlying crime.
For
The
you-
problem, it seems to me, is that we're conflating two intents. Intent to agree with others and an intent to do the crime. And so I don't see why you couldn't have the general intent of knowingly with regard to the agreement, even though the specific intent for the underlying crime is included also. Is that making sense to you?
It does. But I think, that once, if you get to, I think, that would bring us back to the 215202 culpable mental state section under subsection H. Person acts intentionally or with intent with respect to the nature of such person's conduct. And in conspiracy, the conduct is just the agreement to fulfill this crime. And if there has to be intent within the conspiracy to fulfill the crime, then I think if you enter into a conspiracy knowingly, then I would argue as to whether or not you've actually entered into a conspiracy if there's no intent to actually do the crime. And it kind of brings us back to what would be the proper level of culpability, because if it doesn't one, then under 215202E, one is required, but it also says that intent, knowledge, and recklessness suffices. And I don't think that there's an argument for one can recklessly enter into a conspiracy. And if there has to be intent for the underlying crime to be committed, then I think that intentional would be the appropriate mental state to instruct on.
Counsel, you're out of time,
Yes.
but before you sit down, without putting words in your mouth, you acknowledged you're basically swimming upstream on calling this harmless.
I think that's fair to say, yes.
All right. In response to the question Justice Johnson asked minutes ago, tell us your best argument why we should do what you want us to do on this particular conviction.
I do believe that conspiracy requires an intentional conduct of the defendant, and that knowingly is not enough to satisfy the elements of conspiracy. And on top of that, considering that the jury was misled, given the overt act issue, I don't think that there's a reasonable possibility that this was proven properly to a jury, and therefore I don't think that the state carried their burden of proof once these errors are taken into consideration.
I don't think you've
I'm
recited verbatim what our standard is. He was reciting it earlier.
Oh.
We have to be firmly convinced
Yes.
that the jury would have reached a different verdict, basically. You have anything to add
Oh, okay, yeah.
besides what you've said
Yeah,
so
yeah,
far?
yeah, excuse me, I misunderstood. That I mean, as far as I think that the jury probably relied on discussion and planning and convicting, just because that's the easiest one. It's the first one. That's one that definitely occurred. And again, I think that whether or not there was a fully formed intent to commit the conspiracy, I think that could come back different had the jury been properly instructed on the definition of intent. And again, I understand it's difficult to intuit what jurors would do had things changed, but I do believe that these errors prevented the jury from even having an opportunity to really make the correct choice, and therefore I do think this is reversible error. I do think that another jury, given the correct instructions, may come to a different result. I hesitate to say definitely because I don't know. I can't know that. But I do feel that these errors prevented the jury from having the opportunity.
Very well. Thank you, counsel.
Thank you.
We appreciate the arguments from both counsel this morning. Court will take this matter under advisement. This time, the court is in recess for 15 minutes.
All right.